High courts and the central government significantly influence alternative dispute resolution rulemaking. They establish statutory frameworks and procedural rules ensuring effective dispute resolution. Key legislation includes the Arbitration and Conciliation Act 1996 and the Legal Services Authorities Act 1987. These bodies shape the legal landscape, facilitating efficient arbitration processes.
Alternative dispute resolution rulemaking is grounded in statutory frameworks like the Arbitration and Conciliation Act, 1996, and the Legal Services Authorities Act, 1987. High courts and the central government are pivotal in shaping these frameworks, ensuring effective dispute resolution. Their contributions are essential for establishing procedural rules that govern arbitration, mediation, and conciliation processes. High courts possess rulemaking powers under Section 122 of the Civil Procedure Code and other statutes. They establish rules for subordinate courts and procedural guidelines for alternative dispute resolution, ADR. This includes formulating rules for conciliation, mediation, and Lok Adalat procedures, ensuring a structured approach to resolving disputes outside traditional court settings. Section 89 of the Civil Procedure Code empowers high courts to promote alternative dispute resolution, ADR, methods like mediation, conciliation, arbitration, and Lok Adalats. High courts provide practice directions and procedural rules to ensure effective implementation of these alternative dispute resolution processes, enhancing efficiency and reducing litigation burdens. High courts can establish procedural rules for arbitration under the Arbitration and Conciliation Act, 1996. This includes guidelines for filing petitions under Section 9 for interim measures and Section 34 for setting aside awards. These rules ensure a structured approach to arbitration, enhancing efficiency and consistency in legal proceedings. The Delhi High Court Mediation and Conciliation Rules, framed under the Civil Procedure Code and Arbitration Act, outline detailed provisions for appointing mediators and conducting proceedings. These rules emphasize confidentiality, set timelines, and determine mediator fees, ensuring structured and efficient mediation processes. The central government wields extensive rulemaking powers under pivotal statutes such as the Arbitration and Conciliation Act, 1996, and the Legal Services Authorities Act, 1987. These powers enable the government to notify rules that ensure the effective implementation of alternative dispute resolution mechanisms, fostering a more streamlined and uniform legal process across the nation. Under Section 84 of the Arbitration and Conciliation Act, 1996, the central government can notify rules to implement the Act's provisions. This includes procedural guidelines, arbitrator qualifications, and fast-track arbitration, ensuring consistent alternative dispute resolution practices nationwide. The Arbitration and Conciliation Amendment Act, 2019, empowers the central government to establish rules for arbitrator qualifications under Section 43J. It also oversees the maintenance of the Arbitration Council of India and issues model rules for arbitration conduct, ensuring standardized practices and enhancing the arbitration framework. The central government, under Section 29 of the Legal Services Authorities Act, 1987, is empowered to establish rules for Lok Adalats and legal services. This includes appointing panel lawyers, setting procedures for Lok Adalats, determining honorariums for conciliators, and ensuring confidentiality in proceedings. State governments, via state legal services authorities, can create specific rules and guidelines for Lok Adalats and conciliation procedures. This allows for tailored approaches that address local needs while aligning with the overarching framework set by the central government, ensuring effective legal service delivery at the state level. Rulemaking powers are crucial for ensuring procedural clarity and consistency, enhancing the efficiency of alternative dispute resolution, ADR mechanisms. They promote access to justice and significantly reduce judicial backlog, making the legal process more streamlined and accessible for all parties involved. Courts emphasize the importance of rulemaking by high courts and the central government for effective alternative dispute resolution, ADR. This includes setting clear timelines, defining mediator qualifications, and establishing fast-track arbitration norms. Such judicial interpretations ensure that ADR processes are efficient and accessible, aligning with the broader goal of reducing judicial backlog. Recent developments in rulemaking include the introduction of digital alternative dispute resolution platforms and rules for online dispute resolution. The central government has issued notifications regarding arbitrator qualifications and fast-track arbitration, enhancing efficiency and accessibility in the alternative dispute resolution process. Delays in rule notification hinder timely implementation, while inconsistencies across states create confusion. Continuous updates are essential to align with evolving alternative dispute resolution practices, ensuring rules remain relevant and effective. Addressing these challenges is crucial for maintaining the integrity and efficiency of alternative dispute resolution systems. High courts and the central government work together to shape alternative dispute resolution rulemaking. Effective rules boost alternative dispute resolution's credibility and effectiveness. Harmonized, updated rules are essential for future alternative dispute resolution growth.